में मैं आप लोगों के साथ कॉन्स्टिट्यूशनल लॉ के लैंडमार्क इम्पॉर्टेंट केस लॉज डिस्कस करूँगी जो आपके अपकमिंग एग्जामिनेशन में आपको हेल्प करेगा. सो लेट्स स्टार्ट. फर्स्ट इम्पॉर्टेंट केस इज़ बिजॉय इमैनुअल वर्सेस स्टेट ऑफ केरला. In this case, court held that right of free speech and expression also include right to remain silent and that only standing for the national anthem showed proper respect. Next case is Rajwala versus the state of Haryana 2015. In this case, court held the constitutionality of Haryana Panchayati Raj Act, and the act disbarred person in Haryana from the right to contest Panchayati election on the basis of certain restrictions like educational qualification, arrears clause, etc. Next important case is K. Veeraswamy versus Union of India. In this case, court held that no FIR against a High Court or Supreme Court judge can be filed unless President consults CJI and CJI allows it. So this is regarding only High Court and Supreme Court judges. Next important case is Delhi Judicial Service Association versus State of Gujarat 1991. In this case, guidelines against arrest of judicial officer, permission of district judge or High Court judge is required. So this is regarding all judicial officer arrest, and for that the prior permission of district judge or High Court judge is required. Next important case is SP Gupta versus Union of India, that is first judge's case 1981. In this case, the word consultation used under Article 124, it was held that this does not mean concurrence. And next important case is Supreme Court Advocates on Record versus Union of India, that is second judge's case 1993. In this case, it was held that under Article 124, the word consultation does not mean concurrence, and collegium system evolve in this case, which was 1 plus 2, CJI plus 2 senior most judges. Actually, in this case, this word consultation means concurrence was held, so there is a typing error. In Supreme Court Advocate on Record case, it was held that consultation means concurrence. Next important case is Re-Presidential Reference 1998, which is called third judge's case. In this case, collegium means CJI plus 4 senior most judges. So what will constitute the collegium? This was held in this case, third judge's case. Next important case is Supreme Court Advocates on Record versus Union of India 2015. This was fourth judge's case. In this case, primacy of the CJI in judicial appointment was upheld, and National Appointment Judicial Commission, which was introduced by 99th Amendment, was struck down as unconstitutional in nature. Next important case is Naresh Mirajkar versus State of Maharashtra 1966. In this case, it was held that judiciary is a state while performing administrative functions and not while performing judicial functions. Next important case is Vishakha versus the state of Rajasthan 1997. In this case, guidelines pertaining to the sexual harassment of women at workplace was held by the Supreme Court of India. Next important case is Sahara versus Security and Exchange Bank of India 2012. In this case, doctrine of postponement was held, postponing media publication to ensure fair trial. Next important case is Shara Banu versus Union of India 2017, which was triple talaq case, and in this case, triple talaq was held as unconstitutional in nature. Next important case is Nalsa versus Union of India 2014. Very important judgment जो कई बार judicial examination में पूछ लिया गया है. In this case, Supreme Court held that transgenders as third gender and to be given government job under OBC category. Next important case is Shankari Prasad versus Union of India 1951. In this case, court held that Parliament can amend fundamental rights law under Article 13 does not include a constitutional amendment. Next case, Sajjan Singh versus State of Rajasthan 1964. In this case, the main issue or question was, can the Parliament amend the basic structure? So this was also relating to the amendment power of Parliament. Next important case is Golaknath versus State of Punjab 1967. In this case, court held that Parliament cannot amend fundamental rights. Under Article 13, subclause 2, law includes a constitutional amendment. In this case, very important doctrine of prospective overruling was laid down. Next, very landmark judgment, Keshavananda Bharti versus State of Kerala, 1973. In this case, basic structure doctrine was laid down, and in this case, Supreme Court held that Parliament can amend fundamental right but cannot amend the basic structure. And part of Article 31C, which barred judicial review, was struck down. Next case is Minerva Mills versus Union of India, 1980. In this case, Article 368 subclause 4 and Article 368 subclause 5 was struck down as unconstitutional. Part of Article 31C struck down, which gave primacy to all directive principles of fundamental rights, and harmony which between directive principle of state policy and fundamental rights was emphasized. Next case is Ajay Hasia versus Khalid Mujib, 1980, and R.D. Shetty versus International Airport Authority, 1980. In both of these cases, test for determining the other authority under Article 12, which defines the state. So the test was laid down in these two cases. Next important case is A.K. Gopalan versus State of Madras, जिसको habeas corpus case भी कहते हैं. In this case, Supreme Court held the procedure established by law under Article 21 does not mean the due process of law. And in the next case of Menka Gandhi versus Union of India, 1978, Supreme Court held that procedure established by law under Article 21 means due process of law. And right to go abroad was also held as a facet of Article 21. Next case is Attorney General of India versus Lachma Devi, 1985. In this case, public hanging is violative of Article 21. It was held by the Supreme Court. Next important, very landmark judgment, Justice K.S. Swamy versus Union of India, 2017, in which it is held that right to privacy is a facet of Article 21, right to life and personal liberty. So right to privacy is a fundamental right. After this judgment, it is very clearly declared by the Supreme Court. Next important case is Balaji Raghavan versus Union of India, 1995. In this case, national awards such as Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri, national awards are titles within the meaning of Article subclause 1 of Constitution of India. So in this case, it was held that these are actually not titles. The national award which was given, the Padma Shri, Padma Bhushan or Padma Vibhushan, these are not the titles within the meaning of Article 18. So these can be conferred by the governments of India. Next case is State of West Bengal versus Anwar Ali Sarkar, 1951. In this case, court held that there must be a nexus between the classification and the object of the act which makes the classification. So this was a case relating to territorial nexus. Next important case is M.R. Balaji versus State of Mysore, 1962. In this case, a special provision of reservation should be less than 50%. Caste can be one of the criteria, with other criteria such as place of habitation, poverty, etc. to determine backwardness, but caste cannot be a sole factor. So this case was relating to the reservation. Next, very landmark judgment, Indira Sahni versus Union of India, 1993. In this case is also relating to the reservation, and in this case, Supreme Court held that reservation beyond 50% limit is not permissible. That will be unconstitutional in nature. The first point was reservation in promotion not permissible. It diluted by Article 16 subclause 4A via 77th Amendment. Creamy layer test not applicable to the SC and ST. This was also a very important point. This was laid down. And next point, reservation beyond 50% is not permissible. Next point, caste is a predominant test for assessing backwardness. Next important point, carry forward rule for vacancy is not permissible. And next important point, it upheld the 27% reservation for OPCs in public offices. Next judgment is Ajit Singh versus State of Punjab 1999. In this case, Supreme Court held that getting reservation in promotion does not grant consequential seniority for SC and ST candidates. Catch-up rule was laid down under which senior general candidates who were promoted after SC and ST candidate would regain their seniority over SC/ST candidates promoted. This was diluted by addition of a clause with consequential seniority in Article 16. Next important landmark judgment is M. Nagaraj versus Union of India 2006. In this case, reservation in promotion can be allowed if three test factors are shown. First, demonstrate backwardness, demonstrate inadequacy of representation, and third, overall efficiency of the administration should not get compromised. So this was the three tests for the reservation in promotion was laid down in this case. Very landmark judgment. Held per incurium in Judicial Singh versus Lakshmi Narayan Gupta. To the extent it asks for demonstrating backwardness for ST and SC, it goes against the Indra Sani finding that there need not be shown any data for backwardness for SC/ST. So the Judicial Singh versus Lakshmi Narayan Gupta 2018, which is also very recent judgment. In this case, Supreme Court held that there is no need to show the data to demonstrate the backwardness of SC and ST community. Next important judgment is Ashok Kumar Thakur versus Union of India 2008 Supreme Court. In this case, Supreme Court held that caste is often used interchangeably with class and can be called as a basic unit in social stratification. Creamy layer principle cannot be applied to SC and ST as they are separate backward class by themselves. The question was restricted to whether Article 15 subclause 5 insofar as it applied to state institution violated the basic structure. That part of Article 15 subclause 5 which referred to private unaided and educational institution was excluded from the scope of inquiry. Court upheld the application of the provision to the state institution. In this case, constitutionality of Article subclause 5 actually was upheld by the court, and court also upheld the 27% quota for OBC in educational institutions. Next important judgment is State of Madras versus Champakam Dorajan 1951. In this case, admission to medical and engineering colleges in Madras in proportion based upon caste and religion was challenged. Court rejected the argument that Article 46 could be used to provide reservation since directive principle could not go against the fundamental rights of the citizen. And after this case, actually Article 15 subclause 4 was introduced by the First Amendment Act in 1951. So this case is important because this led to the addition of Article 15 subclause 4. Next important judgment is Mohini Jain versus State of Karnataka. In this case, Supreme Court held that right to education is a fundamental right at all levels, primary, secondary and higher. And state was under a constitutional mandate to provide educational institutions at all those levels. Next important case, Unni Krishnan versus State of Andhra Pradesh 1993. In this case, Supreme Court reiterated Mohini Jain case and held that right to education only Supreme Court reconsidered the Mohini Jain case, and in this case, Supreme Court held that right to education extend to citizen only up to the age of 14 years. Private institution had a right under Article 19 subclause 1 subclause G that entitled them to complete autonomy. So the important point in Unni Krishnan is, in this case, Supreme Court actually restrict the educational right only for the children up to the age of 14 years. Next important judgment is the TMA Pai versus State of Karnataka 2002. In this case, setting up of an educational institution would be an occupation under Article 19 subclause 1 subclause G. This scheme framed by Unni Krishnan was illegal and unconstitutional. It overruled Unni Krishnan to that extent relating to the scheme. And then state cannot regulate the admission policies of unaided educational institutions which are run by minorities. However, some rules can be prescribed to maintain academic standards. Minority institution will have to admit to as a reasonable extent non-minority students in their institutions. Next important judgment is Islamic Academy of Education versus State of Karnataka 2003. In this case, Supreme Court held that a state can provide reservation in favor of financially or socially backward sections of society in order to ensure transparency in admission and fee structure. The court resorted to the setting up of committees to give effect to the judgment in TMA Pai case. Next important case is PA Inamdar versus State of Maharashtra, and in this case court held that setting up of committees to fix fee structure seats in private educational institution ran contrary to the judgment in TMA Pai, hence overruled Islamic Academy to that extent. State cannot impose its reservation policy on minority and non-minority unaided private colleges including professional colleges. So this is a very important point in this case, which was held that state cannot impose its reservation policy on unaided private colleges whether they are minority or non-minority. But incorporation of Article 15 subclause 5 via 93rd Amendment Act is diluted the ratio of PA Inamdar and TMA Pai. State could now provide by law reservation in the state as well private institution as well which are aided or unaided. However, minority educational institutions were left out. So in minority education still government cannot provide reservations. Next important case is L. Chandra Kumar versus Union of India. In this case, Supreme Court held that judicial review is a part of basic structure of the Constitution. Court held that Article 323 subclause A and Article 323 subclause B struck down as it affects the power of the High Court of judicial review. So the clause 2 subclause D of Article 323 A and clause 3 subclause D of Article 323B was specifically struck down, which affect the power of High Court regarding judicial review. And these two articles are actually relating to the administrative tribunals. Next important case is Vaman Rao versus Union of India 1981. In this case, court held that all laws put under the 9th schedule of the Constitution before the date of Keshavananda Bharati decision will be immune from judicial review. All laws put under the 9th schedule after Keshavananda Bharati case will be open to the challenge on the ground of violation of basic structure doctrine. Next important case is IR Kohilo versus State of Tamil Nadu 2007 Supreme Court. In this case, twofold test laid down to determine the validity of any law put under Article 9th schedule. First, whether the law violates fundamental rights. Second, whether the violation also result in violation of basic structure of the Constitution. If yes, then the law will be struck down. Supreme Court held that some fundamental rights to be a part of basic structure of the Constitution, but stopped short of holding all fundamental right to be a part of basic structure. So all fundamental rights are not the part of basic structure, and fundamental right can be amended but not the basic structure. So basic structure cannot be amended. Next important case is P. Rathinam versus Union of India 1994. In this case, Supreme Court held that Section 309 of IPC is a cruel and irrational provision. It may result in punishing a person again who has suffered agony. Actually, this section of IPC is relating to the attempt to suicide, and in this case, court held that this section is unconstitutional in nature, and the person who has suffered agony would also be suffering ignominy because of his failure to commit suicide. So this was held as unconstitutional in this case, Section 309 of IPC. Next case in this line was Gyan Kaur versus State of Punjab, 1996, very landmark judgment. In this case, Supreme Court held that right to life under Article 21 is inherently inconsistent with the right to die, as is death with life. In furtherance, right to life, which include right to live with human dignity, would mean the existence of such a right up to the natural end of life. It may further include death with dignity, but such existence should not be confused with unnatural extinction of life, curtailing natural span of life, and it overruled P. Rathinam versus Union of India. In this case, Supreme Court, the most important landmark finding was right to life does not include right to die, and therefore it overruled the P. Rathinam case, and Section 309 IPC is constitutional. It was held that in this case. Next important judgment in this line was Aruna Shanbhog versus Union of India, 2011. In this case, Supreme Court issued a set of broad guidelines regarding the passive euthanasia in India, and Supreme Court held that passive euthanasia is constitutional in India. It held that the decision to withdraw treatment, nutrition, or the decision to discontinue life support must be taken by the parents, spouse, or close relatives, or in absence of them by the next friend. This decision requires approval from the concerned High Court. Next important judgment, very recent judgment in this line relating to the right to death was Common Cause versus Union of India, 2018. In this case, Supreme Court held that right to die with dignity is a fundamental right, and passive euthanasia is permissible, not active euthanasia. This was already held in Gyan Kaur case. Passive euthanasia is constitutional. The difference between active and passive euthanasia is that in active euthanasia, something is done to end the patient's life, while in passive euthanasia, something is not done that would have preserved the patient's life. Court also upheld the validity of a living will. Living will is a written document that allows a patient to give explicit instruction in advance about the medical treatment to be administered when he or she is terminally ill or no longer able to express informed consent. It includes authorizing their families to switch off life support in case a medical board declared that they were beyond medical help. Next case is Kyoto Holohan versus Judicial, 1992. In this case, Supreme Court held that Para 7 of 10 schedule, which was inserted by 52nd Amendment 1985 of the Constitution, it was held as ultra vires as it excluded the judicial review. So Para 7 specifically was held ultra vires. Next important judgment is Indira Nehru Gandhi versus Raj Naren, 1975. In this case, Supreme Court held 39 amendment which added the Article 329A as unconstitutional and violative of basic structure. Next important judgment is People's Union for Democratic Right, PUDR versus Union of India, 1982. In this case, Supreme Court held that when a person provides labor or service to another for remuneration which is less than the minimum wage, the labor or service provided by him clearly falls within the scope and ambit of the word forced labor under Article 23. Next important judgment is Santosh Kumar versus Secretary Ministry of HRD, 1995. In this case, Supreme Court held that teaching of Sanskrit alone as an elective subject in CBSE can in no way be regarded as against secularism. Indeed, our constitution requires giving up of fillip to Sanskrit because of what has been stated in Article 351, in which while dealing with the duty of the Union to promote the spread of Hindi, it has been provided that it would draw whenever necessary or desirable for its vocabulary primarily on Sanskrit. So Article 351 is relating to the promotion of Hindi language. So let's come to the next important case, that is Rev. Stanislaus versus State of MP. Right to propagate religion under Article 25 does not include the right to convert by fraud or deceit or allurement, and therefore upheld the constitutional validity of the laws enacted by Madhya Pradesh and Odisha legislature prohibiting conversion by force, fraud or allurement. Next case is Association for Democratic Reform versus Union of India 2002. Court mandated the disclosure of information relating to the criminal antecedents, educational qualifications, and personal assets of the candidates who are contesting elections. So this case is also important. Next case is Lok Prahari versus Union of India 2018. Center directed to amend the rules as well as the disclosure form filed by the candidates along with their nomination papers to include the sources of their income and those of their spouses and dependents, and disclosure of government contract where candidates or their associates have direct or indirect interest. Next important judgment is Lily Thomas versus Union of India 2013. In this case, Supreme Court held that Section 8 subclause 4 of Representation of People's Act 1951 was prospectively struck down as unconstitutional, being beyond the legislative competence of the Parliament. Section 8 subclause 4 provide that if a MP or MLA has been convicted of a criminal offence, such as MP or MLA can continue to remain such MP or MLA can continue to remain and discharge his duties as a member of the House. If within 3 months of the conviction he or she has filed an appeal or revision against such conviction, then this protection is no more available to the MP and MLA, and thus on conviction they lose their seat. Next important judgment is Abhiram Singh versus CD Commission 2017. In this case, Supreme Court held that Section 123 subclause 3 of the Act prohibits any candidate, his agent or person consented by such candidate or agent from soliciting votes or discouraging votes against voting for a rival candidate on ground of religion, race, caste, community, language by declaring such conduct as corrupt practices. The court has read this provision to disallow any reference to the religion, caste, community or language of the candidate or his rivals or voters to secure votes or prejudice the electorate against a rival in an election. These cases actually are relating to the elections. This Association for Democratic Reform and Lok Prahari, Lily Thomas, Abhiram Singh. Next in this line is Ashwini Kumar Upadhyay. These all are relating to the elections. In this case, Ashwini Kumar Upadhyay case, Supreme Court held that MP or MLA cannot be debarred from practicing in court. Legislatures cannot be styled or characterized as full-time salaried employee, for there is no relationship of employer and employee. Bar Council of India rules prohibit an advance from being a full-time salaried employee of any person, government firm, corporation or concern, so long as he continue to practice. Next important judgment in the same line is Public Interest Foundation versus Union of India. In this case, Supreme Court held that politician cannot be barred from contesting elections on framing of charges. Guideline issues to prevent criminalization of politics. First, while filing their nomination, the candidate must declare if there are pending criminal cases against them in court. Second, political parties are also responsible for putting up details of criminal cases filed against their candidates on their website. Third, Parliament must legislate on the matter to ensure that candidates with criminal antecedents do not enter public life or become lawmakers. So this case was relating to 2018, so the name of the case is also very important here. Next important judgment is Sarla Mudgal versus Union of India, a very landmark judgment case which emphasized on the need for uniform civil code. Next case is Keshav Singh 1965 case. Supreme Court held that it could not be disputed that in the matters of privileges, the House was the sole and exclusive judge, provided such privilege could be found in Article 194 subclause 3. The question whether a privilege as claimed by the House was provided by Article 194 subclause 3 or not was a matter for the court to decide. The nature and scope of Article 194 subclause 3 was thus to be determined by the court. So this was relating to the parliamentary privileges, the Keshav Singh case. Next important judgment is P.V. Narasimha Rao versus State 1998. Court held that those who took bribe but did not vote will be liable for prosecution under Prevention of Corruption Act, as they were not protected or entitled to the immunity under Article 105 sub clause 2 of the Constitution, whereas those who voted will be protected even though they had taken bribes. Next important judgment, very important, Swapnil Tripathi versus Supreme Court 2018. In this case, Supreme Court allowed the live streaming of the court proceedings. Next important judgment, Shreya Singhal versus Union of India 2015. In this case, Supreme Court struck down section 66A of IT Act 2000. So this case is also asked in judicial and other competitive examination. It was held unconstitutional because it is violative of Article 19, subclause 1, subclause A of Constitution. Next important judgment, Joseph Shine versus Union of India 2018, Supreme Court. In this case, Supreme Court held that section 497 relating to the adultery of IPC as unconstitutional in nature. And Article 198 subclause 2 of CRPC, which is relating to the husband to give exclusive right to prosecute his wife's lover, manifestly it is arbitrary and unconstitutional. Next judgment is Justice K. Puttaswamy versus Union of India 2018. In this case, Supreme Court held that Aadhaar as a reasonable restriction on individual privacy, upholding the passage of Aadhaar Act as a money bill. The majority opinion upheld the PAN Aadhaar linkage but declared that linking Aadhaar with the bank accounts and mobile SIM cards is unconstitutional. The card was not necessary for the children aged between 6 and 14 under the Sarva Shiksha Abhiyan, as right to education was a fundamental right. Statutory bodies like CBSE and UGC cannot ask students to produce their Aadhaar card for the examination like NEET and JEE. Section 57 of the Aadhaar Act was struck down and it was used by the government to compel private companies to demand Aadhaar verification for services. Next important judgment is Indian Young Lawyers Association versus State of Kerala. This is Sabarimala judgment. In this case, Supreme Court held that exclusion of the women from the temple of Lord Ayappa was a discriminatory practice which violates the freedom of religion of the women's devotees. Next important judgment is Navtej Singh Johar versus Union of India. This is also 2018. In this case, Supreme Court held that section 377 IPC is irrational, indefeasible and arbitrary in nature, and section 377 is read down, not completely held unconstitutional, rather some part of section 377 held as unconstitutional in nature. The sexual orientation of each individual in the society each individual in the society must be protected on an even platform, for the right to privacy and the protection of sexual orientation lies at the core of fundamental right guarantees by Article 14, 15 and 21 of the Constitution. Respect for individual choice is the very essence of the liberty under the law. Section 377 as IPC assumed the characteristics of unreasonableness, for it becomes a weapon in the hand of the majority to seclude, exploit and harass the LGBT community. So this case is important regarding section 377 IPC is read down in this case. Next important judgment is Olga Talis versus BMC, Bombay Municipal Corporation 1985. In this case, Supreme Court held that right to livelihood is a facet of Article 21 of the Constitution. Next important judgment is John Velatum versus Union of India 1997. In this case, Supreme Court declared section 118 of Indian Succession Act as unconstitutional, violative of Article 14. It restricts the right of Christian having a nephew or niece or other relative as regard his power to bequeath his property for religious or charitable purpose. Next important judgment is DC Wadhwa versus State of Bihar 1987. In this case, Supreme Court held the power to make an ordinance is to meet an extraordinary situation, and it should not be made to meet political ends of the individual. So this is relating to the ordinance relating power, DC Wadhwa. In this case, Supreme Court further held that promulgation from time to time is a subversion of the democratic process and a fraud on the Constitution. If ordinance making was made a usual practice, creating an ordinance Raj, the court could strike down re-promulgated ordinances. Next important judgment is Krishna Kumar Singh versus State of Bihar 2017. In this case, court held that the requirement of placing the ordinance before the legislature is mandatory. Repromulgation of the ordinances is a fraud on the constitution and a subversion of the democratic legislative processes. The court also held that the satisfaction of the president under Article 123 and of the governor under Article 213 while issuing ordinances is not immune from judicial review. So Krishna Kumar Singh is also relating to the ordinance making power. The next case in the same line of ordinance is A.K. Roy versus Union of India 1982. In this case, Supreme Court held that President ordinance making power is not beyond the scope of judicial review. However, the need to exercise judicial review over President decision arise only when there are substantial ground to challenge the decision and not at every casual or passing challenge. So this case is very important, A.K. Roy, because in this case Supreme Court held that President ordinance making power is not beyond the scope of judicial review. Next important judgment is ADM Jabalpur versus Shivkant Shukla 1976. Which is also called habeas corpus case. In this case, the issue was whether an order issued by the President under Article 359 of the Constitution suspend the right of every person to move any court for the enforcement of right to personal liberty under Article 21 upon being detained under a law provided for. The court answered it in the affirmative, and this case actually considered as a bad precedent, ADM Jabalpur case. Next judgment is BP Singhal versus Union of India 2010. In this case, Supreme Court held that President, in effect, the central government has the power to remove a governor at any time without giving him or her reason and without granting an opportunity to be heard. However, this power cannot be exercised in an arbitrary, capricious or unreasonable manner. The power of removing governors should only be exercised in rare and exceptional circumstances for valid and compelling reasons. The mere reason that a governor is at variance with the policies and ideologies of central government or that the central government has lost confidence in him or her. So this is actually relating to the removal of governor. This case is also important. The name of the case, BP Singhal versus Union of India 2010. Next important judgment is Society for Unaided Private School of Rajasthan versus Union of India 2012. In this case, Supreme Court held that every citizen has a right to establish and administer schools under Article 19, Subclause 1, Subclause G, so long as the activity remain charitable. Such an activity undertaken by private schools supplements the primary obligation of the state. The state can regulate by law the activities of private schools, including admission, by imposing reasonable restrictions in the public interest under Article 19, Subclause 6 of the Constitution. The quota obligation imposed on private unaided non-minority schools is in the public interest and is a reasonable restriction for the purpose of Article 19, Subclause 6. Therefore, Right to Education Act shall apply to private unaided non-minority schools. Regarding unaided minority schools, Article 29, Subclause 1 of the Constitution protect the right of minorities to conserve their language, script or culture, and Article 30, Subclause 1 protect the right to establish and administer schools of their choice. So this was the case which was relating to Article 29 and 30, Society for Unaided Private Schools of Rajasthan versus Union of India. Next important judgment is Pramati Education and Cultural Trust versus Union of India 2014. In this case, Society for Unaided Private Schools of Rajasthan versus Union of India, so far as it holds that 2019 Act is applicable to aided minority schools, is overruled, and Constitution 93rd Amendment Act 2005 inserting Clause 5 of Article 15 of the Constitution and Article 86th Amendment Act 2002 inserting Article 21A, Right to Education, of the Constitution do not alter the basic structure or framework of the Constitution and are constitutionally valid. Right to Education Act is not ultra vires of Article 19, Subclause 1 and G of the Constitution. So the name of this case is very important, because in this case Supreme Court held that Right to Education Act is not the ultra vires of Article 19, Subclause 1 and G of the Constitution. Next important judgment is S.R. Bomai versus Union of India 1994. In this case, Supreme Court laid down certain guidelines as to prevent the misuse of Article 356 of the Constitution, which is relating to the state emergency. Based on the report of Sarkaria Commission on Center and State Relation 1988, the Supreme Court enlisted a situation where the exercise of power under Article 356 could be proper or improper. Supreme Court also held that secularism is one of the basic features of the Constitution. Secularism is positive concept of equal treatment of all religions. So these 2 points are very important. First is relating to Article 356 state emergency, and the second point is relating to the secularism is one of the basic feature, and it is a part of basic structure of Indian Constitution. Next important judgment is Ismail Faruqi versus Union of India 1995. In this case, the power of acquisition, Supreme Court held that power of acquisition is the sovereign and prerogative power of the state to acquire property. Such power exists independent of Article 300A of the Constitution or earlier Article 31 of the Constitution, which merely indicate the limitation on the power of acquisition by the state. Such acquisition per se does not violate Article 25 or 26. What is protected under Article 25 or 26 is a religious practice which form an essential and integral part of a religion. The practice may be a religious practice but not an essential part of religious practice. While offer of prayer or worship is a religious practice, its offering at every location where such prayer can be offered would not be an essential and integral part of such religious practice. So the name of the case is here important, which is Ismail Faruqi versus Union of India. Next important judgment is S.P. Mittal versus Union of India 1983. In this case, Supreme Court held that word religious denomination in Article 26 of Constitution must make their color from the word religion, and if this be so, the expression religious denomination must also satisfy the 3 conditions. First, collection of individual who has a system of belief or doctrines which they regard as conducive to their spiritual well-being or common faith, and second is common organization, and third, designation by a distinctive nature. Next important judgment is Commissioner Hindu Religious Endowment Madras versus Shri Lakshmidhar Tirtha Swamiyar of Shri Shirur Mutt 1954. In this case, court laid down the essential practice test. This is also relating to the secularism. So these all our cases are in the line of secularism, and this case, Supreme Court observed what constitute an essential part of a religion will be ascertained with reference to the tenets and doctrine of that religion itself. So the essential practice test was laid down in this case. Next important judgment is Selvi versus State of Karnataka 2010. In this case, the court declared that the 3 prominent police interrogation technique, narco analysis, lie detector test, and brain mapping test, these 3 are violated an accused personal right against self-incrimination under Article 20 subclause 3 and her right to life and personal liberty under Article 21 of the Constitution. And this case is very important, Selvi versus State of Karnataka, because the judgment is relating to Article 20 subclause 3 and Article 21. Forcible administration of the above test would be an unjustified intrusion into the mental privacy, and it could lead to further stigma for the victim. Next judgment is MC Mehta versus Union of India 1986. In this case, the court laid down the concept of public liability and absolute liability. This is relating to absolute liability, is relating to the torts and of industrialists relate to protect the environment from pollutions. Next judgment is Rural Litigation and Entitlement Case Dehradun versus State of Uttar Pradesh 1987. In this case, Supreme Court laid down the concept of sustainable development. Next case, Indian Council for Environment Legal Action versus Union of India 1999. In this case, Supreme Court laid down the polluter pay principle. Next judgment is Animal Welfare Board of India versus A. Nagaraj 2014. In this case, court prohibited Jallikattu and other animal races and fights, and held that animal fights incited by humans are illegal, even those carried out under the guise of tradition and culture. Next, Subhash Kumar versus State of Bihar 1991. In this case, Supreme Court held that right to life include right of enjoyment of pollution-free water and air. for full enjoyment of life. Next is D.K. Basu versus State of West Bengal 1997. Very important judgment, because in this case Supreme Court specific guidelines were laid down by the Supreme Court to be followed by the police while making arrest. And after this judgment, certain changes were also introduced in the CRPC. Next judgment is Sheila Barsi versus State of Maharashtra 1983. Court laid down the guidelines conferring protection to the women prisoners in police lockups. Next judgment is Prem Chandra Garg versus Excise Commissioner UP Allahabad 1963. In this court held that an order which this court can make in order to do complete justice under Article 142 between the parties must not only be consistent with the fundamental right, but it cannot even be inconsistent with the substantive provision of relevant statutory laws. Next judgment is Union Carbide Corporation versus Union of India 1991. Court held that prohibition or limitation or provisions contained in ordinary laws cannot ipso facto act as prohibitions or limitation on the constitutional powers under Article 142. Next judgment is Supreme Court Bar Association versus Union of India. In this case, Supreme Court observed that the power under Article 142 cannot in any way be controlled by any statutory provision, but at the same time these powers are not meant to be exercised when their exercise may come directly in conflict with what has been expressly provided for in statute dealing expressly with the subject. Article 142 of the Constitution is actually relating to the inherent powers of the Supreme Court, and these all cases are relating to the 142. This is Prem Chand Garg case, Union Carbide Corporation case, Supreme Court Bar Association case. So let's come to the next case, Subhash Mahajan versus State of Maharashtra 2018. In this case, Supreme Court laid down the guidelines to prevent abuse of scheduled caste and scheduled tribe. Prevention of Atrocities Act 1989 held that no absolute bar on anticipatory bail, arrest to be made after a preliminary inquiry. Public servant cannot be arrested without prior sanction. But this judgment's ruling is diluted by the amendment made in the Act of SC/ST Act after 2018 amendment. Next judgment is Government of NCT Delhi versus Union of India 2018. Court held that Lieutenant Governor of NCT Delhi is bound by the aid and advice of elected government of Delhi except in the matters of land, police and public order. While holding so, the court has observed that in a democracy, real power must vest in the elected representative, and Lieutenant Governor cannot interfere in every decision of the Delhi government. The word any matter employed in the proviso to clause 4 of Article 239 AA cannot be inferred to mean every matter. Next important judgment is Maru Ram versus Union of India 1980. In this case, court held that the power under Article 72 is to be exercised on the advice of central government and not by the president on his own, and on the advice of the government binds the head of the republic. So this is relating to Article 72, that is pardoning power of the president. This case name is important, Maru Ram versus Union of India 1980, because in this case Supreme Court held that power under Article 72 is exercised on advice of central government and not by the president on its own. Next judgment is Kehar Singh versus Union of India 1989. In this case, Supreme Court laid down the order of president cannot be subjected to the judicial review on its merits except with the strict limitation defined in Maru Ram case. Next judgment is Ipru Sudhakar versus Government of Andhra Pradesh 2006. In this case, Supreme Court held that it is a well-set principle that limited judicial review of exercise of clemency power is available to the Supreme Court and High Court. Granting of clemency by the President or Governor can be challenged on the following ground: the order has been passed without application of mind, the order is malified, the order has been passed on extraneous or wholly irrelevant consideration, relevant material has been kept out of the consideration, or the order suffers from arbitrariness. Next important judgment is Triveni Bain versus State of Gujarat 1989. In this case, court held that undue long delay in execution of the sentence would entitle the convict to approach the Supreme Court under Article 32 or High Court under Article 226 and get his sentence commuted. Next judgment is Shatrughan Chauhan versus Union of India 2014. In this case, court observed that inordinate and inexplicable delay in execution would preclude carrying out the sentence even in cases where the convict in question has committed an offence of terrorism. This case name is actually very important. In this case, Supreme Court overruled Devendra Singh Bhullar versus State of NCT Delhi 2013, which had ruled that a delay in disposing of a mercy petition by itself is insufficient ground for commuting the sentence of those who are convicted to the death penalty under anti-terrorism statute. The name of the case here is very important, both Shatrughan Chauhan and Devendra Singh Bhullar case. Next judgment is Union of India versus Tulshiram Patel 1985. The court held that dismissal, removal, reduction in rank of a person convicted on a criminal charge is in public interest and therefore it is not violative of Article 311 subclause 2 or Article 14 of the Constitution. Next judgment, Purushottam Lal Dhingra versus Union of India 1957. In this case, Supreme Court held that Article 311 is available only when dismissal, removal, reduction in rank is by way of punishment. So it is difficult to determine as to when an order of termination of service or reduction in rank is amount to punishment, and Supreme Court laid down two tests to determine when termination is by way of punishment. So two tests were laid down in this case of Purushottam Lal Dhingra relating to Article 311. First was whether the servant has a right to hold the post or the rank, and second is whether he has been visited the evil consequences. Next judgment is Union of India versus Balbir Singh 1998. Supreme Court held that court can examine the circumstances on which the satisfaction of the president or governor is taken under the proviso to the Article 311 subclause 2. If the court finds that the circumstances have no bearing on the security of state, the court can hold that satisfaction of the president or governor which is required for passing such order has been vitiated by wholly extraneous or irrelevant consideration. Next important judgment is Campaign for Judicial Accountability and Reform versus Union of India 2017. In this case, Supreme Court held that Chief Justice is the master of roster, followed the ratio of State of Rajasthan versus Prakash Chand 1998. So the name of the case is important because in this case, Supreme Court held that CJI is the master of roster. In this whole list, the case name which are very, very important are this one, this Delhi Judicial Service Association versus State of Gujarat, SP Gupta, Supreme Court Advocate on Records, and rest of the whole list you must read. And the recent judgment which are relating to 2015, 2017 and 2018 are very, very important because chances are very high that such case laws may be asked in the upcoming examination. Justice Gupta Swami, very important, and all the cases of 2018. So I have discussed with you. So these are very landmark recent judgment which are very recent of 2021 and 2020. So first case is Union of India versus Rajendra Shah and others 2021 Supreme Court. In this case, Supreme Court upheld 2013 judgment of Gujarat High Court which struck down the provisions of Constitutional 97th Amendment Act 2011 to the extent it introduced the Part 9B in the Constitution to deal with the cooperative societies. So R and Shah case is very important because in this case Supreme Court struck down some part of 97th Amendment Act. Next important judgment is State of Haryana versus Rajkumar Bittu 2021 Supreme Court. In this case, Supreme Court observed that power of governor under Article 161 of the Constitution to commute sentence or to pardon will override the restrictions imposed under Article 433A of the CRPC. Next important judgment is Salim D. Agbotwala versus Shamji Odavji Thakkar and others 2021. In this case, Supreme Court held that plaint cannot be rejected under Order 7 Rule 11 sub clause D CPC if the issue of limitation is a mixed question of law and fact. Next important judgment is ML Sharma versus Union of India 2021, which is relating to the Pegasus snooping case. In this case, Supreme Court discussed the scope of judicial review in the matters pertaining to the national security. Next case is Prem Shankar Prasad versus State of Bihar 2021. Supreme Court held that absconding and or proclaimed offender are not entitled to the anticipatory bail. In the State of Gujarat versus Narayan 2021, Supreme Court held that furlough is not a legal right. Next judgment is Shorab Sharma versus Subdivisional Magistrate East and others versus 2021. Supreme Court held that a private vehicle would amount to a public place in context of COVID-19 regulations. Next important judgment is Division Bench of Supreme Court comprising Justice Sanjay Kishan Kaul and Harishikesh Roy passed the interim direction permitting the women candidate to take the part in the NDA examination. So Kush Kalra case is relating to the NDA examination in which Supreme Court permit the women candidate to take this exam. And Secretary Ministry of Defence versus Babita Punia case. In this case, Supreme Court grant the permanent commission to the women in 10 non-combat services unit at 3 months and held them to be eligible to hold and command post. This case is very landmark because in this case, Supreme Court grant permanent commission to the women in Indian Army. Next important judgment is Gautam Navlakha versus NIA 2021. In this case, Supreme Court held that court can order for the house arrest under Section 167 CRPC in the appropriate cases. Section 167 CRPC is relating to the remand and default bail. Next judgment is Bajranga versus State of Madhya Pradesh 2021. Supreme Court. In this case, Supreme Court held that right to property is still a constitutional right under Article 300A of the Constitution. In Paramveer Singh Saini versus Baljeet Singh 2021, Supreme Court held that CCTV installation in the police station is important and Supreme Court direct the installation of CCTV cameras in the police station. Next judgment is Lakhvir Singh versus State of Punjab 2021. In this case, Supreme Court held that Section 6 of the Probation of the Offenders Act 1958 is mandatory in nature. Next judgment is Satish Ragde versus State of Maharashtra 2021. In this case, Supreme Court held that Bombay High Court. This is not relating to the Supreme Court. This is Bombay High Court judgment, which was very controversial. In this case, Bombay High Court had held that no sexual assault if there was no skin-to-skin contact, even with the sexual intent, and this was actually overruled later on by the Supreme Court. Next important judgment is Kerala Union of Working Journalists versus Union of India, which is Siddiq Kappan case 2021. In this case, Supreme Court held that fundamental right to life is available to the under trial prisoners as well. Next important judgment is Compaq Enterprises India versus Beant Singh 2021. Supreme Court. In this case, Supreme Court held that compromise decree would not serve as an estoppel where the compromise was vitiated by fraud, misrepresentation or mistake. Next very important judgment, Maratha quota case, Dr. Jayashri Lakshman Rao Patil versus CM and others 2021. In this case, Supreme Court struck down Maratha quota as unconstitutional in nature. 11-member commission headed by retired Justice N.G. Gaikwad recommended the Marathas should be given the reservation under the socially and educationally backward classes, and thereafter the Marathas were given the reservation as well. But in the Indira Sahni judgment, actually it was held that which was very important and landmark judgment, that 50% reservation should not exceed, and if the reservation exceeds the 50% limit, then it will be unconstitutional in nature. So on this behalf, Supreme Court in this case held that Maratha quota reservation, because it exceeds the 50% limit, so it is unconstitutional in nature. and bench unanimously upheld the constitutional validity of 102nd constitutional amendment. Section 102nd Constitutional Amendment of 2018 introduced Article 338B and Article 342A in the Constitution. Article 338B deals with the newly established National Commission for Backward Classes, and Article 342A deals with which empowers the President to specify socially and educationally backward communities in a state. Next judgment is Chief Election Commissioner of India versus M.R. Vijay Bhaskar, 2021. In this case, Supreme Court held that freedom of media is a sine qua non for democracy. Name of the case is very important here. Next judgment is Farzana Batul versus Union of India, 2022. In this case, court held that though the professional education is not included under the fundamental rights of the Constitution, but the professional education although not a fundamental right, but state has an affirmative obligation to facilitate access to the education at all levels. And some of the other very important recent judgment are Anuradha Bhasin versus Union of India, 2020. This is relating to right to internet access. Next is Swapnil Tripathi versus Supreme Court, which is relating to the live streaming of the court proceeding. Vinita Sharma versus Rakesh Sharma. In this case, Supreme Court held that daughter is a co-partner by birth in the Hindu co-partnership property. And Justice K.S. Puttaswamy versus Union of India, I have already discussed with you. In this case, Supreme Court held that right to life and personal liberty include right to privacy, and right to privacy is a fundamental right. So after this judgment, the Personal Data Protection Bill 2019 actually was passed, and it is India's first attempt to domestically legislate on the issue of data protection. It is a draft version prepared by a committee headed by retired Justice B.N. Sri Krishna. And the judgment Pegasus spyware probe. This is Manohar Lal Sharma, M.L. Sharma versus Union of India. This is Pegasus snooping case. So actually the name of the case, which is Justice K.S. Puttaswamy, this judgment will affect the upcoming judgment as well. So if like Manohar Lal Sharma case is pending in the court, and this is relating also to the data protection, so in this case also the effect of Justice K.S. Puttaswamy judgment will be there. Next judgment is Shabrulu Leela Prasad Rao versus State of Andhra Pradesh, 2020, Supreme Court. In this case, Supreme Court held that 100% reservation to the ST candidates, out of whom 33%, which means 1/3, shall be women for the post of teachers in the schools in the scheduled area in the state of Andhra Pradesh. Such kind of reservation is not constitutionally valid, because this reservation is of 100%, and 100% reservation is arbitrary and unconstitutional in nature. So these were the landmark constitutional judgment plus some of very important recent judgment of 2017, 18, 19, 20 and 21. I hope this video will help you in your upcoming examination. Thanks for watching.